Welcome everybody to the Bold Today Show. I am JD Houvener, managing partner and owner here at Bold Patents Law Firm. You've made it here weekly every Wednesday at 9 a.m. Pacific and noon on the East Coast. We are live across Facebook and YouTube, as well as our Twitch channel for some of those gamer connections we have. I'm excited today. I've got a special guest, another client inventor of ours, wanting to share where they are at. And she, I'll give you a little hint, she is a owner of two patents, a design and a utility patent. I'm excited to bring her on shortly and have you ask any questions that may come up. For those that are listening from our ALVO.com community, I'll be getting to your questions later in the segment. And we'll be getting into a special offer as well on how to get a hold of a copy of this book right here, Bold Ideas, The Inventor's Guide to Patents. So what I'll do without further delay is put in our disclaimer. I am an attorney. We are a law firm, and so we are full of legal disclaimers. So yeah, so please read this. If you're listening, if you're new to this, even if you've been around for a while, you know that this is not the place to share confidential information. Do not mention your invention here. This is not the forum. I can be reached via email at jd@boldip.com, of course on our website at boldip.com, and schedule a free screening session with one of our advisors. That'll be the best place to discuss your potential invention. This is a place to mention general questions. What's the patent process? What's the difference between a provisional and a non-provisional, a utility and a design patent, which we'll be talking about hopefully today, and going from there. So welcome. I'm seeing we're getting a couple live viewers on already. Pepe, good to see you. Bring on those questions, fire them away. We're going to do first come, first serve. This is the agenda. So we'll bring on our guest, and then we'll have any questions you've got prioritized ahead of those ALVO questions. All right. So there's the agenda. I do want to mention real quickly the link here to schedule. If you're ready to go, even if after listening or while you're getting started here, you're ready to get started, here's the link to schedule a free screening session with our firm. If you think you've got an invention that may be eligible and you're wondering what the next steps are. So there's that link I just provided. Okay, so let's bring on our special guest. I've got Sarah Dillingham. She is a client of ours at Bold Patents. She is an inventor and now has two issued patents. I mentioned one for design and one for utility for her splint. So Sarah, welcome to the program.
Hello, hiya.
Hi, it's so glad to have you, and thank you for being willing to be brave and be on a live program like this. I wanted to start, if you don't mind, just kind of walk us through what is the invention and then kind of what the current status is.
Sure. So my invention is a splint to be held within a wrist brace. And the reason I invented it is because I have arthritis, and like many people, I have to wear wrist braces on a fairly regular basis. And one of the big problems with wrist braces is that most of the ones on the market will keep your hand very nicely like this in what's called the neutral position. And It really does that with something like this, which is a very straight, well, slightly bent, but mainly straight piece of metal. And the problem with that is it's very rigid. If you fall over, you're going to dig it into your hand and it gets very sweaty. And so like many people with arthritis, I was using these products and I became very dissatisfied with them. And also they're really one size fits all, which never works. So I got together with my business partner, Trevor, who's a hand therapist, and we prototyped a new splint, which we prototyped initially in nylon using a 3D printer. And the whole idea with this is that it's ergonomically shaped. It's not just one bend and straight, it actually curves how your arm curves.
Right.
And it's got a little bit of flexibility in it. It's not completely rigid, which is really important because when you have conditions like arthritic conditions and you're wearing something like this all day, you actually need a little bit of flex in it to do your day-to-day stuff. So that's our product. And we are now at the point where we've had our patents issue and we're looking at production, which we think is, well, it's almost certainly going to be this guy, which is a slightly simplified version for injection molding. So that's where we're at.
Cool. Excellent. Could you hold that up again for me? I mean, I'm seeing that with the one of the stark differences I'm seeing is there's a bunch of holes in there. What's the purpose of that?
They're all perforated, so that's for airflow. We surveyed 500 people who use these products, and the number one thing they said was, my arm gets horribly sweaty because moisture collects under this metal element. So what they really wanted was a way for airflow to, move around the arm and stop sweat and bacteria collecting, and it's very unpleasant. So that allows for that. That's the whole purpose. And we spent a lot of time making sure that we put enough holes in that you can have it nice and cooling and everything, and but also not so many holes that it loses the level of rigidity it needs to keep your hand in the right position.
So does that brace go directly in contact with the skin, and I guess how does it secure to the wrist?
Yeah, so what we have also done, for our launch, as well as working on this side of it, the hardware, we've been working on some soft goods products. So for example, we have, you will have seen, I just put it on. So we basically have designed our own wrist brace, basically soft brace, and it's within a little pocket in here. And we've actually spent as long making this as we have with the splint. So with this guy, we spent a lot of time sourcing fabrics that have moisture wicking and antibacterial qualities. Everything we do is designed with patient input, and it's designed for people with chronic joint pain. So these people have to wear these products day in, day out, and we're able to make them in nice colors. And yeah, that's what we're about. Right. We're going to sell them together as a kit.
There you go. Thank you. Well, I mean, congratulations for sure, making it all the way to the patent being granted, both of them being granted. I wanted to take a quick minute and showcase where you're at right now. You don't just have the patent documents, you've actually got a company and a bit of a marketing effort. So I wanted to showcase your website, and I'll share my screen here briefly with those viewers on. And so tell us a little about Grace and Able.
So Grace and Able is all about making better products for people with joint pain. And one of the big things that we heard coming out loud and clear from the arthritis community is that nobody talks to us, nobody asks us what we want. People just make stuff for us, and it's really ugly, and it's embarrassing to wear, and it's uncomfortable, and no one talks to us. So really at the heart of everything we do are our patients. So I'm going to see if I can do this. I don't think I can. But on our website, we haven't got any products listed yet. We're going to launch in March 2021. But what we have,
where are the products? Right.
Because everyone kept messaging us. I was like, I'll just put it up front. But what we do have under our Read tab in that menu at the top is we've got a few things. We've got a blog. We've got links to our online communities. And we've also got links to a page where people can join our patient panel. What's that's about is that everything we do, everything we design, we do it in conjunction with patients. We're really, really thorough about our patient testing and feedback. And that goes through to every product, the products we're about to launch and the products we're developing now.
Yeah, that's really wonderful. A lot of inventors that we work with are sort of nervous, and you seem to have really taken this on when your patent was still pending in the fall. You took on a testing, process. Tell us about that. What was it like for you?
So I think it's always a really challenging thing, getting the balance between, getting feedback and retaining confidentiality. Because as an inventor, you're always very nervous that I am going to see what you're doing and think, oh, I'm going to steal it and do it fast or whatever. But I did realize that there was just no, we're making this for patients, and there's no point doing it unless I actually get their feedback and I iterate on it. So we had to be a bit brave and jump in, but we did that in a very considered way. So we used non-disclosure agreements. We used liability waivers. So
Yay.
That was very important. It's a health product, so yeah, absolutely. But also everything we do has been supervised by a certified hand therapist, and I've also had input from a rheumatologist as well. So we are really, really thorough with how we conduct all that. those
That's
conversations.
wonderful. Well, your website looks great, and the content on there is nice to see. I think that the focus is patient-centered, you know, and you did that pretty well. And so I'm excited to see those products roll out. You're saying March this year? Is that when you think you'll be launching?
We are planning to launch in March 2021, COVID permitting.
Excellent. Well, really briefly, just because I am a patent nerd, I do want to showcase the actual invention, the cover sheet, just so people that can look that may not be familiar with what a design patent looks like or a utility patent looks like. So give me a moment here. I'll bring on my screen. So we have these patents. This is a design patent. You can tell it's a design patent because of the D here. It's kind of an obvious one. And this was issued, I mean, less than 3 weeks ago, December 15th. And with a design patent, you get 15 years of exclusivity. And it's issued to our inventor, our guest and host here, Sarah Dillingham. So you've got the design patent really is all about the drawing. And so you can see this is drawn out pretty clearly. We've claimed what's in solid line, that shape that you just showed us on camera earlier. And that's really the feature of what the claim is, the scope is. So you're working with Chris and Tom on this to get that accomplished. And you can tell that it was filed back in 2019, the original, and it got eventually issued in late 2020. So there's the design, and the utility looks a little different. So we can see the numbering is different. You know, there's actually fewer than 1 million design patents that have been issued, only 905,000, and over 10 million utility patents issued. So you can see she was number 10,864,105. So the reason is, you know, why utility patents are more popular is because they do provide a lot more scope of rights. And so it's all about the functionality. And while I won't get into the claims here with respect to the timing we have here, claims do cover many different versions and embodiments. And so she has a certain type of nylon that she's using, for example. There's also protection for many other types of material that could be used under the utility. But it's a great approach to have both, because what the utility patent does not cover is the ornamental, the design. And so she's done a really good job in protecting the functionality of what these holes do, what the shape, the ergonomic structure provides, and the benefits you mentioned with respect to the airflow and, you know, support without, you know, fatigue on the utility, and then on the design side, just the way that it looks. And it's going to be a great 2 arrows in your quiver to defend against any infringers. So congratulations on that.
Oh, thank you.
All right. Well, good to hear from you, Flavio. And Pepe, just hang in there. We're going to get to you soon on those 2 questions. So Sarah, what I'm going to do is put you backstage, and I'll ask anyone out there that's listening to ask any questions of you, and then we'll bring you back on to answer questions that may have come up in the next 10 minutes. All right. But thank you so much for sharing. Take care.
Thank you.
All right. So I do want to get to Pepe's question because he is a live listener. So his first question is, if I share information on WhatsApp, is it secure? What do you think? I have shared some illustrations with my brother. Let me see if this, okay, I'll bring that, there it is. And then it goes on, if my inventions has a bunch of ideas, do I need a patent for every idea, or one patent can secure a group of ideas? Okay, let's take those in turn. So WhatsApp, I'm pretty sure that is a software app that is sort of like texting. And hopefully I'm wrong, or hopefully I'm right. Correct me if I'm wrong. And so if that information is public, that's really the fundamental question here, is if what's posted there is not private, if it's available to, you know, any other person of the public, and maybe it's findable through some search repository afterward, then it's feasible that it's available to the public at large, even those that may not be WhatsApp users. So I may need some clarification there. The important thing to note is that what that would do, if it is published, right, and not private, is it would act as a technical publication, meaning it would start the timer. In the US, you have 1 year, a 1-year grace period from when you publish or sell your invention. And so if that were to qualify as a publication, the timer would start, right? So within a year, you have to file a patent application if you're going to on that subject matter that was shared. It can be, in many cases, that it was a partial disclosure. Maybe it was just a non-enabled disclosure is the legal definition, where it's just a really high-level sketch or a picture, and that alone wouldn't allow someone in the field to be able to make or use it. And that could very well be. We'd have to have a discussion confidentially on what was disclosed. Like I said, back to the fundamental question is, when you're making a disclosure or publication, you want to make sure that it's done at a very high level so that it doesn't fully explain your invention. Okay, so next question. You've got a bunch of ideas and you want to just see if we can cover them all under one patent. While there is a rule, a fundamental rule where you're only allowed one patent per invention. And so we have actually done this strategically before, where you file a family of patents, a family of inventions. And what the examiner does, it's part of their job, is they'll say, hold on. You've got 5 separate inventions here, and we're going to restrict you. We're going to make you choose one species, that's what it's called, of what you filed. And the others will have to be sort of sitting, and you can later file divisionals. You can file separate patent applications covering that other subject matter. For the examiners, that's one of their main jobs up front, is to clear and make sure that they can do a search. And they don't want to sign up to have to do a search on 4 or 5 different inventions. They only want to do one, right? That's what they're paid for. That's what their bosses are watching them for their metrics. So they're going to be up against a timeline to get that search completed. So they don't want to sign up for doing even more than one invention. So that's one of the approaches to take. But before we get even that far, likely we'll want to do some diligence up front in terms of patent research. Ideas are just that, right? They're ideas, and they're not necessarily at that invention phase. When you've got an invention, you're able to clearly articulate it, right? Explain it in words or in writing and drawings, so that either you or someone in your field could go make that invention. That's the level of detail you need to have to be at the invention phase. If you're still at the concept and idea, it may be too early to start writing an application. So, and what it'll do, once you finally get to that invention phase and you're able to write it down in more detail, we'll be able to conduct a really high level, a really detailed patent search to confirm that there's nothing else out there in the world like what you've done. And that'll give us a lot more gusto and motivation to write that application and to recommend that you move forward. So I hope that helps answer your question, Pepe. If you have any follow-ups, please feel free. Flavio, let's take yours. The prior art, before officially filing for the allowance, can you be kind to elaborate on that? Let's see, the prior art. Well, when a patent application is allowed, right, which is a huge victory, the examiner says, yeah, there is nothing else similar to your invention, and this is not an obvious version of anything else, any other subject matter that's available. And prior art, is something you know, Flavio, and maybe others don't. Prior art is just a fancy term for other publications, other inventions known in the art, right? What's the status quo? What's the state of the art that's known in the industry? And any publication, right? That can be a patent, could be a Kickstarter article, could be a YouTube video, Facebook video, could act as prior art if it discusses and enables and talks about the same subject matter as what you filed. So if the examiner has allowed your application, that means you're cleared of that prior art investigation. So there is a very small, chance that the examiner can come back in that 3-month window with additional prior art. It can happen. Very rare circumstances where, usually it's larger companies will have their competitors basically do an examination as well, right? They'll be looking at the same doc, and maybe they'll provide prior art to the examiner to help them, right, with their search to try to get their competitor's application rejected. So, but for most solo inventors, small businesses, it just doesn't happen. Once you've been given that green light on the notice of allowance, you're just months away from getting that issuance. So thanks for your question, Flavio. I do want to jump to our ALVO questions, and please keep those live questions coming. I will prioritize those. Just one question came in from ALVO, so I'll share my screen here with everyone, and we'll jump to that. For ALVO, people that don't know what ALVO is, it is a volunteer association where attorneys like myself are privileged to be able to answer questions that come in from around the country. And they're anonymous questions, and I have subscribed to trademark, patent infringement, and patent application questions. And so every week I get these types of questions, and only one has come up this week. You know, maybe we had the holiday, people are not quite as interested in getting questions answered, but this one came in just about a day ago out of Georgia, and a lot of people have been watching Georgia for other reasons politically. So this question starts out, if you have a patent, are you protected? I have a US patent on a product, and I'm trying to license it to a manufacturer. Can the manufacturer get around the patent by having it manufactured outside of the US? Great question. Okay, let me just copy this into the notes here, and I will stop sharing here. Okay. One thing to make sure you understand is that every country has separate patent laws on the books. And so if you have only a US patent, okay, you have rights only in the US, all right? And so what that means is you have the ability to exclude, right, prevent anyone else from making, using, selling, or importing into the US and the US market. And that means also, right, if you only have a US patent, that means you don't have a patent in any other international jurisdiction. So you're not going to be able to prevent individuals or companies from making, selling, or importing that invention in other countries. So that's why it's an important consideration, very important, when you're in that application phase, while your application is pending, to strongly consider filing an international PCT, treaty application, which will allow you additional time to file into foreign jurisdictions. So if your manufacturer, let's say it's in China, okay, there's no patent in China, right? So there's nothing for them to actually get around. That is a risk you're taking, that they could develop and sell and market outside the US, really anywhere. And of course, in China, without any legal mechanism for you to go after them. But in any way that they're impeding on your rights in the US, obviously you should enforce your rights. So I hope that helps answer your question there. Thank you for that. Flavio, okay, so you came in late. Who is your guest? And she invented new women's nylon. No, she didn't. She invented a splint for men and women that both have an arthritic condition. So I'll have her come back on here shortly. Sorry you missed her. That was Sarah, so she'll be back on shortly. Pepe, just one follow-up looks like you said, I mean one invention with a group of designs, then all together to solve a problem. Pepe, I think we're gonna need to talk confidentially. In some cases, you can file a group, right, where it's functional. And maybe perhaps a good example is Sarah's invention. We can bring her back on to showcase. She has, what was patented. Okay, so I'll pull this back up here on the utility side. Yeah, here we go. Whoa, there it is. So you see and this is the utility. Oh, I'll pull it. There it is, utility. We have described and shown this, right? This exact figure with kind of this, figure eight-ish look. It's got the curve for the hands and the ergonomic features. But this could, I think she even showed earlier, the actual holes here can look different. Can have very different shapes. Triangular, oval, elliptical, have quite a few more holes or even fewer holes. And I could imagine there'd be even some flexibility in terms of the shape that could change. Maybe if someone has a medical condition where they need a very high arch, I suppose that could be customized. Those are the types of things, changes or versions of the invention that could all fall within one invention, right? They're embodiments and versions. So whenever possible, we try to include that to, make it efficient. We wouldn't want to file separate patents. And in fact, you really wouldn't be able to get separate patents for different versions. So Pepe, I think you should shoot me an email and we can kind of take a look confidentially at what you've got. All right, thank you for your question. I want to bring Sarah back on. Welcome back, Sarah.
Hello.
All right, so we did have a question come in. You're not inventing nylons, are you?
I am not inventing nylons. No, they were invented a very long time ago.
Very good. No, it's nice. That's very. So, if you wouldn't mind holding up those two for us again,
sure.
if you've got it.
So so this is how these splints, over-the-counter splints, used to be sold. Pieces of metal that are just bent to hold your hand like this. This is our 3D printed prototype, which is ergonomically shaped, made of nylon, but and perforated for nice airflow. And this is our injection molded version, which is slightly simplified for the requirements of injection molding, but it's still got all the ergonomic shaping. It's just we've had to change the holes a little bit. Right.
And maybe what's throwing you off, Flavio, and I learned this when I started at Boeing and learning about different materials. Nylon is a type of plastic, right? It's a different term for plastic. So I think of nylons, right, as a flexible fabric. I don't know why. I suppose it is also plastic. It's just a very thin version of it. Have you guys honed in on materials that you think you're going to be successful with? Or are you still testing those?
Oh, for the splint, yeah. We are. So when we were prototyping, yes, we tried lots of different polymer-based materials, and we were looking for something that had rigidity but a little bit of flexibility. And one of the great things about 3D printing is it allows you to try out lots and lots of different materials in a very affordable way. So we went right from something that was super rigid through to something that was super flexible until we found something at the right point. And then what we do is when we found that, that's what we actually found PA12, so a form of nylon. So that's what we're going to injection molded.
Wonderful. Thank you for that. Well, we're going to wrap up here pretty soon. I just wanted to get your feedback too. What was the patent process like? Be as candid as you can. Going from start to finish. Any feedback?
Yeah, so I was working with Chris at Bold, and he was absolutely fantastic. This is the first time I've applied. I love Chris, he's great. It's the first time I applied for a patent ever in my life. And as you can tell from my accent, I'm British, I'm not American. So applying for a patent, and I've only lived here for 3 years, in the US was very, very daunting. And so I had a really good experience because Chris was very good at explaining everything, every step of the way. And of course, we did have a couple of setbacks, so we had to go back and forth with the examiner. And I've got to say, I did find that a bit scary. But again, he was very, very good at explaining the process. And I think from my side of it, the most important thing was that clear communication of exactly what was happening and when. And feeling like I could ask him questions and just collaborate, and he took like a lot of the the mystery out of it, I suppose.
No, that's wonderful. Really good. I'll take that back to Chris. That's wonderful. Thank you for being on and sharing your invention and your story. I wish you the very best the next couple of months as you're getting ready to launch. So if anyone wants to get a hold of you, what is the best way? Is it through the website, or do you want to give an email out?
Yeah, so either my website, which is graceenable.com, has a contact form, or you can email me at Sarah, SARAH, at graceenable, GRACEANDABLE.com.
Excellent. There it is. All right. And so it's Sarah at graceenable.com. All right. I've got that in the comments here. Wonderful. All right. Well, I don't see any additional questions, so thank you again for being on. We'll touch base. Hang on. We're going to chat backstage after we end the broadcast. But thank you, everyone, for joining the Bold Today show. We'll be on next week. Take care, everybody.
Thanks, Chris. Oh, thanks, JD.
You're welcome.